Hello and welcome to the Ann and Phelim Scoop. I'm Ann McElhinney.
And I'm Phelim 𝙈𝙾𝙀😅.
The Mark Steyn defamation trial is now in its third week and we're still in the courtroom every day.
Yes, we're in Chile, DC. Chile by name, Chile by nature. That makes no sense at all.
Zero sense. Climate scientist Michael Mann, the one suing Steyn for calling his hockey stick graph a fraud, is close to wrapping his case. All our attention is focused on this case, so today we're bringing you the latest episode of Climate Change on Trial.
So Climate Change on Trial, as you probably know, because you're getting the emails, is our podcast where we take the most exciting parts of the trial, the most dramatic events and clashes, and reenact them and put them out on a daily podcast. At one stage, we were the number 6 top science podcast on the planet, so it's been incredibly successful. So do yourself a favor, go over to Climate Change on Trial and listen to all the back episodes, but we're going to give you the latest episode that everyone else is getting today as part of this Ann and Phelim Scoop podcast. Have a listen now. We're going to go straight into it. We're sure you're going to love it. Hello and welcome to Climate Change on Trial.
I'm Ann McElhinney.
And I'm Phelim 𝙈𝙾𝙀😅.
This is a daily podcast from inside the DC defamation trial of writer and broadcaster Mark Steyn. Steyn has been sued for defamation by climate scientist Professor Michael Mann. Steyn described Mann's famous hockey stick graph as a fraud. Mann is also suing writer Rand Simberg, who made similar comments.
We're presenting the podcast in a very special way by having actors reenact court transcripts verbatim, so you get the most exciting exchanges from the court every day.
So welcome to Climate Change on Trial, Day 9, Straw Man. So we're in our fancy smancy new courtroom, but some things haven't changed. I mean, I just said this morning, I really, really need to say this when we're recording today. It is incredible to me that every day of this jury trial, the jury do not turn up on time every day. And actually, I think it's gotten worse, not better. And I think it doesn't help that they don't get an admonishment for that behaviour. So this morning, everyone is there. People who are earning, are getting $2,000 an hour are sitting there waiting for the jury. The judge didn't come in until 10 o'clock, didn't appear until 10 o'clock to tell us that 4 jurors had been missing and we had to wait on the 4 jurors. And this has happened every day. We just had a repeat of this and it's extraordinary. And he kind of joked this evening at the end of the court day. He kind of said, why don't I say to you jurors, why don't I say to you come in at 9:15? Ha ha ha. And I just thought, and we should, Phelim, you've talked about this before, that in certain jurisdictions, this would really not be tolerated.
As far as I know, in most jurisdictions, this would not be tolerated. In the British system, where I've covered a lot of court cases, the Irish system, and I was talking to someone today, the Canadian system, the jurors would be late. They would get a roasting from the judge. If they continued to be late, the judge would fine them. I've been in court, or I've heard of judges who will send out a police officer with a bench warrant to bring the jurors in. And then the next thing is you fine the jurors if they won't come in. And then the ultimate punishment is you sequester the jury. I think the way the jurors have been treated in this particular court doesn't reflect well on the judge. The judge has been, in my opinion, indecisive. He's changed his mind. And we'll talk about that later on. Halfway through the trial, he's still talking about whether he's going to let important documents in or not. He's not fully in control of his courtroom, I think. So we would hope that is going to change, but maybe probably it won't. So
it's well worth saying, however, I shouldn't even say however. Phelim and I are extremely punctual and a little bit, it's kind of a fault. Somebody invites us over to their house and we arrive 3 minutes before the time, and that is a little bit of a fault. But this does drive me nuts. You have all these people waiting and it's every day. It's not once, it's every day, and it's not one juror, it's many jurors. Anyway, we need to move on.
And it's not 5 minutes.
And it's not 5 minutes. No, it's never 5 minutes. So today we heard from Rand Simberg, who is Mark Steyn's co-defendant.
He's the one who wrote the original article that compared the Penn State investigation into Mann and compared it to the investigation into child molester Jerry Sandusky. The investigation, not as Mann says frequently in the witness box, comparing him directly to Sandusky. It's the cover-up, as Nixon would say. And there's also today a lot of arguing over the admissibility of several reports that Mann wants admitted into evidence. So Mann's lawyer, John Williams, questioned Rand Simberg about the truth of statements that he made in the original article in this case, and the article was called "The Other Scandal in Unhappy Valley." I suppose Williams was trying to establish that, first of all, Simberg made false statements, but more importantly, he made them deliberately and maliciously.
Like, that's the important thing, right? In a defamation, that it was deliberate and malicious. Because obviously you can make a mistake, but it's your intention that is at stake here.
Did he know, right?
Yes.
So, have to say, Simberg performed well.
I thought so. I liked the way Simberg behaved. I thought, to me, he would have appealed, I think, to the jury. I thought he was sober and serious, and he wasn't flashy in any way. And we're going to hear later about what a clever guy he is. By the way, he's a bit of a rocket scientist. In fact, I think is how we colloquially describe a guy like him.
He was a refreshing change, actually, from Mann, who tried to deflect all the questions put to him. Simberg was soft-spoken, but firm, actually, wouldn't accept anything from Williams, was his own person and wouldn't accept anything that Williams threw at him.
But to get a sense of Simberg, I think with this first reenactment we're going to come to here is, gets to the very heart of what this is all about, and the heart of why he holds his views about climate change. Take a listen to this reenactment.
You have written that schools shouldn't be allowed to show Al Gore's documentary other than as an example of hysterical, lying propaganda. Did I read that correctly?
You did.
When you say Gore's documentary, you're referring to the documentary entitled An Inconvenient Truth that was produced and directed by Al Gore, right?
Yes.
And that's the one for which he won a Nobel Prize?
That's true, he did.
And why do you say that schools shouldn't be allowed to show that documentary?
Because it was lying propaganda. It's frightened a whole generation of young people to not even want to have kids. This is the first generation in human history we have where people are saying they don't want to have kids.
And you are attributing that to the documentary of Al Gore?
It certainly contributed to it.
So that's what it's all about, the terrible consequences that have come from Mann and his fellow scientists pushing global warming alarmism. I was really glad that this came up because it's something that it really upsets me, actually, to realise that young people, or so many of them, are depressed because they are constantly being bombarded with this very, very, the end is nigh, doom, and everything is awful, and we're all going to die. And this is exactly why so many of them have pledged not to have children, because they don't want the planet to die tomorrow, kind of thing. But it's I thought it was really, he came across very well, and he said it in a very sincere way.
Yes. Then Williams asked Simberg a little about his background. I thought, again, this just made Simberg look good from my point of view. We'll play a reenactment of Simberg's answers, and it just shows really how qualified he is, how smart he is, how reflective he is.
Yeah, this is a man, a thinker and a very clever and intelligent person. Let's hear that.
Your resume says you're an expert in space systems and space travel, right?
Yes, space technology, space. I do a lot of consulting on space in general, regulations, technology, business.
Ms. Weatherford called you a rocket scientist. Is that fair?
To the extent such things exist. We're engineers.
You're an engineer?
Yes.
And you have 3 academic degrees?
Yes.
1 in engineering science?
Yes.
1 in mathematics?
Applied mathematics.
And you have a Master of Science in Technology, right?
Yes.
You told me that you are familiar with statistics?
Well, I have degrees in math. That's one of the things that you have to learn to get that kind of degree.
You're an adjunct?
Not now. I was at the time I wrote the blog post.
What's the difference between a blog post and an article?
You have to understand blogging. Articles tend to be the kinds of things in the newspaper. A blog post could be as simple as a link and brief comment. Blogging is, you see something of interest, you're looking around papers, around other blogs, you say, well, that's interesting. I think I'll talk to my readers about it. Link to it, have some comments on it. Somebody else might pick it up. Get comments within your blog post. Other blogs will respond, you might link to them. You might update your post. It's more of a dynamic living thing.
Yeah, Simberg is willing to admit he made some mistakes in his blog post. And I don't know, I think that probably will work okay with the jury.
Yeah.
But again, Williams has to prove he knew he was making mistakes, or he not that he was knew that what he was saying was false, and that's the legal definition of malice. So defamation, it has to be false, it has to be this, has to cause damage, but it also has to be malicious. And malicious doesn't mean nasty. Malicious means you knew it was false. So take a listen to this exchange and pay attention to the by now infamous NSF report, National Science Foundation report. It's going to be a huge issue later on in this episode.
You acknowledge that you have made errors in your article, right?
Yes.
Some of them about the Penn State report and some about the NSF report, correct?
Yes, of course. The Penn State report. Even your own client got confused between the inquiry and the investigation's report. It's understandable some people will get confused.
Simberg maintained the position he took in his blog post that the Penn State investigation into allegations of Mann's scientific misconduct was a whitewash and a straw man setup. Here's that reenactment.
What wasn't a real, true investigation?
Penn State was not. And based on that, NSF was not an allegation. They were straw men because I didn't know anybody who had accused Professor Mann of research misconduct. And that's the only thing he was cleared of by Penn State and NSF.
NSF was not a real investigation. Is that what you're saying?
It was not an investigation into the things we were accusing him of.
Okay. Tell me what you were accusing him of in your article.
I was accusing him of unscientific behavior.
That's all?
He was shown to be behaving in an unscientific manner.
Well, you were accusing him of deception, were you not?
That too, but again, that's not research misconduct, Mr. Williams. I was not accusing him of plagiarism, fabricating data, or falsifying data. Nobody was accusing him for those things except Penn State. And then they set up a straw man so they could knock it down.
Okay. You were accusing him of unscientific misconduct and deceit, right? Deceptions?
I'm not sure if I have that word in here.
Well, why don't you look?
Oh, yes. Hockey stick deceptions, yes.
Yeah, deceptions. And you were accusing him of data manipulation to keep the blade on the famous hockey stick, right?
Yes.
Again, I was impressed. Very level, admits his mistakes, stands firm. It's a hard thing to argue against that the university that would cover up a child rapist to protect the star football program would cover up to protect their star climatologist. It's a logical argument.
Yeah, no, it's very logical. If they would cover up for someone doing the worst possible thing imaginable, well, surely they'd cover up for somebody doing a much, much less awful thing, much on a totally different scale. Yes. It's logical. It makes sense. Mm-hmm. They were willing to do an incredible thing to cover up the worst thing ever. Why wouldn't they want to cover up something, obviously on a completely different scale, but something that made them look bad, that made the college look bad? Why wouldn't they do that?
Yeah, that seemed to be, as Mark Steyn said in his open, it was all about brand protection.
So today we actually got, not a lot of proper testimony, because a lot of the time was spent arguing over the admissibility of the National Science Foundation report that allegedly exonerates Mann. Judge Irving dismissed the jury for a long lunch break, 2-hour lunch break, by the way, while he heard arguments from both sides about why this NSF report and reports from the UK House of Commons Select Committee should be allowed into evidence. And this went on and on and on. And, some of it was really impressive, by the way.
And there was one from the House of Commons and the other one was from the Climate Research Unit.
So two reports from the UK and one report from the States that were in question.
So a bit of background. The National Science Foundation report is a memo that cleared an unnamed professor at an unnamed university of accusations of fraud and scientific misconduct. Now, it's pretty clear that it is about Dr. Mann.
But it's so weird, right?
Yes.
They don't name the college, they don't name the professor, and the report itself is not signed. And this came, extraordinary. But anyway, the argument went on for a long time.
So it's apparently based on the Penn State report, which is a weakness of it, because Steyn and Simberg say that wasn't a serious investigation. It was a straw man investigation, actually. So Mann and his lawyers claim that both these investigations were legitimate and want the NSF report admitted as evidence. As I say, 2 other reports in the UK were at issue. One was done by, as Mark Steyn put it, backbenchers with no power in the House of Commons, and the other one was done by the Climate Research Unit at the University of East Anglia. They also said Mann committed no misconduct. So, I mean, it went back and forward, and this is why I would be critical of the judge. I mean, has already gone to the Court of Appeal. So I don't even know why the judge is allowing them to argue it. And the judge did note that the Court of Appeal said these reports were not relevant to the case and not necessarily admissible.
And there are rules. So there are very strict rules about admitting evidence from reports and government reports and national reports, and and to work out the provenance and the power of those reports. And basically there are very strict rules. And Mark 𝙤𝙤𝙀𝙀𝙀, I have to say, that's Mark 𝙤𝙤𝙀𝙀𝙀, who is Rand Simberg's lawyer. I thought did an incredibly good job of explaining these rules and explaining why it meant that these reports should not be admissible.
Basically, you just can't take something from the internet and say this is a report. It has to be. But listen, let's let Mark 𝙤𝙤𝙀𝙀𝙀 explain it. And we're going to have several reenactments. And the first person you're going to hear is Judge 𝙤𝙤𝙀𝙀𝙀, who at this stage in the argument seems to be skeptical of bringing in the report. But let's see if he maintains that skepticism. So let's take it away there, Judge 𝙤𝙤𝙀𝙀𝙀.
The NSF report is a 3-page memorandum. The Court of Appeals concluded that an investigation was conducted, that people were interviewed. They considered a host of information before reaching a conclusion and deciding to close out the investigation. I've even noted that the title seems to be ambiguous. The university is not named. The subject is not named. But it seems from all of us here in this room that the investigation itself was a continuation and a revisitation of the Penn State investigation and conclusions resulting in NSF's conclusion.
Sure. When the Court of Appeals is considering an anti-SLAPP motion, basically considering dismissing a case on free speech grounds, it's not making final decisions. It's essentially acting as a gatekeeper. In light of the evidence we see here today, is there an appropriate enough likelihood that the plaintiffs potentially could prevail on their claims, such that we should not terminate the case now in favor of the First Amendment protections that the anti-SLAPP law was designed to implement? Ruling those reports admissible wasn't done based on an evidentiary hearing. It was done on a paper record. And there are certain assumptions that underlie a paper record when you don't have actual testimony. One of those assumptions is that the parties will appropriately authenticate and lay a foundation for their evidence. The second is that the relevance of the evidence is what it appears to be, based on the paper without testimonial evidence.
𝙤𝙤𝙀𝙀𝙀 added that Simberg said he did not rely on the report when writing his blog post, so it could not be introduced that way. And the big weakness was that Mann had produced no one to swear the document was authentic and about Mann and Penn State. So, this was the problem. And we'll hear, there was an enormous amount of conversation about Rule 44 and the fact that you would need to have someone to come and authenticate the document and speak to it. And the plaintiffs had 12 years to produce someone to authenticate the document and hadn't managed to do so.
And as he says, he can travel up 8 metro stops and call into the NSF headquarters and get it authenticated. But they didn't do that. Let's let Mr. 𝙤𝙤𝙀𝙀𝙀 explain that.
We had years of discovery. And we've now had what? Is this our 6th day of testimony? And what has been shown after those 6 days of testimony? What's been shown is that my client, Rand Simberg, did not rely on the NSF memorandum. He testified that he did review the NSF memorandum and that he saw a host of problems that made, in his words, a mess. And so he chose not to rely on the memorandum. There was no testimony in that way for Mr. Simberg when this case was up on a collateral order appeal. What else has been shown? Or maybe a better way to put it, what hasn't been shown? When the Court of Appeals received those reports from Mr. Williams and the plaintiff made certain representations about what they were on the paper, the Court of Appeals was entitled, I believe, to rely on those representations and did. But now we're in court, where the rubber meets the road on complying with the rules of evidence. In that regard, the plaintiff has done nothing consistent with Rule 44A1 to prove a domestic record. You have to prove a domestic record in accordance with Rule 44A1, which hasn't been done here.
𝙤𝙊𝙘 said Mann's lawyers had failed to do the work needed to present the document in court.
Just more of the same. Why didn't you do the work? You had 12 years.
Let's hear that.
Rule 44 is what you have to do to even prove the document. And Rule 43I says that you need to have either an official publication of the record, official publications of the record are down the street in the Library of Congress, or at an agency office here in Boston, Arlington, wherever. We don't have that. A copy attested by an officer with a legal copy of the record. That would have been exceptionally simple to do in this case. The parties took dozens of depositions. Probably there could have been an affidavit from a custodian of the NSF. We don't have that. Your Honor, there's a threshold issue here that isn't applied. You don't just print it off the internet and go with it. You don't just print random things off, then come to court with them, wave them around and say this is it. That's not how the system works.
In the end, 𝙤𝙊𝙘 said it was probably irrelevant, even if they could authenticate it as an NSF document. The contents were too vague to be brought before the jury. Let's hear 𝙤𝙊𝙘 explain that.
The fact of the matter is the NSF report is entirely ambiguous about what it is and isn't investigating. Even if you could surmount the issues, is it about Penn State, even though it doesn't say Penn State? Is it about Michael Mann, even though it doesn't say Michael Mann? The report's first finding is that Michael Mann was not a principal investigator in 2000 until late 2001, 2002, when he then became a principal investigator. And it is hopelessly ambiguous about exactly what it is that the NSF officials were investigating. And we submitted a bench brief saying when you have these types of ambiguous records, you actually need a real witness to testify. Someone 8 metro stops away could have done this. There were dozens of depositions in this case. It never happened. At the end of the day, the defendants are not the party who had an obligation to make these evidentiary showings. It's not our burden. It's the plaintiff's burden. And there are undoubtedly, with such competent and experienced counsel, strategic reasons why the plaintiff would not have wanted to provide these records. Providing these records would give us an opportunity to examine the officials and realize that we are correct. That the things the plaintiff believes were actually investigated were investigated.
So then the judge asked for Mark Steyn to opine on these various reports that were being argued about. We'd heard, obviously, from Rand Simberg's lawyer, 𝙤𝙊𝙘. Now it was time for Mark Steyn to speak to these. And obviously, he started by saying, I agree with everything that Mr. 𝙤𝙊𝙘 has said. So his co-defendant, he wanted to add his voice to that. But then he was able to speak in a specific way to these British reports, because obviously with his vast array of passports, he can speak to those things. And I thought this was, and it was kind of fun, right?
Yes, he took the opportunity to inform the court about British parliamentary procedures and do a bit of British Empire boosterism. So let's hear Mark Steyn. This opens with Judge Irvine, and Mark then takes it away.
All right, I'll hear from Mr. Steyn. Yes.
I would like to agree with everything that Mr. 𝙤𝙊𝙘 just said. I don't need to revisit the NSF report because as I've testified at deposition and in the witness box last week, I didn't rely on it. I can't tell one agency beginning with N from another agency beginning with N. I think that's all a lot of nonsense. So I believe that admitting it, unless it's admitted very, very narrowly, would actually be prejudicial to me. To turn to the British reports...
Yes, and I wanted Mr. 𝙤𝙊𝙘 to speak to that as well.
But I do know a little bit about that. I think Mr. 𝙤𝙊𝙘 said there were 8 metro stops from here. The relevant London repository is 8 tube stops from my pad in London. And neither of these reports are in there. Neither of them qualify as records in the United Kingdom, and I'm concerned about this, because it has come from plaintiffs' counsel routinely, what is referred to as the House of Commons report, which makes it sound like a report from the British Parliament. It is not. It is a report of a committee that is made up of 14 backbench MPs, and it is not an official record. It is not held by the related ministerial department, and it is not held in the British office. The University of East Anglia is not a public university, as that term is defined in the United States. And that is not a public record. The British Public Office has a lot of stuff in there. It has the Constitution of my country and the constitutions of about a third of all the nations and territories on the face of the earth. So it doesn't have room for a report, not only from the University of East Anglia, but from a minor select committee of the House of Commons, which is not the same as a select committee of House of Representatives. The British Parliament is one of the oldest parliaments on earth, and these go back to 1979. And they do not have the same status. And as I have said to this court, a non-public record in the United Kingdom does not become a public record simply by being put on a flight to Dulles. I would have a different view of this had they hadn't had 12 years to arrange this. If they could produce Sir Muir Russell or one of his committee to authenticate the document, but absent Sir Muir and his friends, this is not a self-authenticating document. And the same with whatever time-serving hack was chairman of a backbench committee. And I do strongly urge the court, I don't want to have to interject every time it's referred to as a House of Commons report, but it was a report of 14 peripheral figures to the House of Commons. There is no way under the district's own rules that these are self-authenticating documents, and they should not be omitted. I don't think you use the term backbench here, but backbench, if I'm correct, it's a Canadian and, English term. But backbench by definition means you're not official. And as you know, because we introduced it, we filed with the court that the 1958 Public Records Act applies only to government departments and executive agencies of His Majesty's government. Neither the University of East Anglia nor the backbench MP's report meets that definition.
And to me, this is a bit of a killer point. 𝙤𝙤𝙀𝙤𝙀 agreed with Mark Steyn, but added that the Court of Appeals and the rules of DC Superior Court, where we are having this hearing, were quite clear about what could and what could not be brought before the jury and what had to be done in advance.
I'll speak to Rule 44. Rule 44/A2 governs foreign records, and it says that each of the following is evidence that a foreign official record, it is admissible. 1, an official publication of the record. We have no idea what an official publication of the record constitutes. What it constitutes in the United Kingdom, no clue. Now, I want to relay a little story here, Your Honor. It may have been 2019, Mr. Williams, myself, and Mr. Coyne sat in a conference room, the ward room in my office, to talk about these foreign records. And Mr. Williams said something along the lines of, you guys aren't really going to fight the authenticity of this, because if you do, we're going to need to make a trip through Europe. And we'll go and depose their officials in Europe, and we'll get to the bottom of this. And we said, well, if that's what it takes, that's what it takes. Well, needless to say, while there were dozens of depositions in this case, my passport didn't get stamped. Again, I think that all of the same concerns that I raised from the NSF report are here, plus many others. I'm not going to presume to know what type of university constitutes a public office, if any, in the United Kingdom. I'm not an expert on United Kingdom law. And there hasn't been an affidavit or other proof of United Kingdom law in this case. I mean, the rules of evidence are not meant to be a stab in the dark. That's the plaintiff's burden, and it didn't get satisfied. I think if the Court of Appeals judges were hovering up there today looking down on this, they'd say, wait a minute, you made us write a 60-page opinion in this case, but you didn't bother to authenticate all the things you told us were going to be public records? I don't think they would be looking at this, Your Honor, saying, well, we already decided this. I think they'd be looking at all parties saying, you've got to be kidding me.
John Williams, Michael Mann's lawyer, he wanted to get the reports before the jury in order to establish malice. That would then allow him to claim that Steyn and Simberg knew that Mann had been cleared by a handful of government investigations, but had decided to write false and harmful statements about him anyway. That's the legal definition of malice. He said the jury was educated enough to understand what the documents were and what their weaknesses were.
So following the lunch break, the judge came back with his decision. He would allow the NSF report to be submitted into evidence, but not allow the UK reports to even be mentioned in questioning or testimony. I was shocked, by the way, that the NSF report was allowed in, given the arguments that 𝙤𝙤𝙤𝙤 particularly had proffered. I just thought it was extraordinary that a report will be entered into evidence that does not name him, does not name Mann, does not name the university, has not been signed by anyone, and there's no one there to authenticate the document. And after them quoting these lines and these rules that are extremely important, so I was surprised.
It's pretty surprising that, I mean, look, and they could have authenticated it. They've had 12 years to get the president himself to stamp on it, it is a big shock, and it's not good. It looks like the judge can be cajoled into overturning his own judgments, the Court of Appeal's judgments, and the rules. Not good for justice, I think. But anyway, after this was resolved, John Williams continued his questioning of Rand Simberg with this. It's a funny exchange, actually, and we liked it. And I don't think John Williams, Michael Mann's counsel, scored any points here.
Do you recall questions about your thinking that your judgment was better than the judgment of the Inspector General?
Yes, I do recall that.
And the reason you said you thought your judgment was better was because you thought that the Inspector General was a politician, right?
Right.
And when you told me this, you did not even know who the Inspector General was.
I didn't have to.
You didn't have to because you knew they were a politician?
High-level government officials are driven by politics.
You don't know if was the Inspector General a man or woman?
I don't know.
Republican? Democrat?
I don't know.
So that was really the end of Williams trying to prove that Rand Simberg wrote with malice, as in Rand Simberg was wrong, but he also knew he was wrong, which is an important part of, it's an essential part of proving you were defamed. So do you think he proved that Simberg was wrong? Simberg admitted he made some mistakes, but that Simberg dishonestly wrote this and knew he was wrong?
No, I don't think that was established. I definitely don't think that landed as a point.
Right.
Definitely
well,
not.
Hopefully the jury will stick with the law. I mean, or they may just go with the emotional verdict. But if they're sticking to the law, in your opinion, he didn't hit the bar there.
I didn't think so.
Okay, well, let's see. Then, I suppose, he was going for the emotional hammer, where he went through this explicit list of the crimes and in explicit details the crimes that Jerry Sandusky committed, and said, you're comparing my client Michael Mann to these horrible crimes. And Rand Simberg, of course, says, no, I'm not. I'm comparing the cover-up investigations. Again, it was emotional. It was graphic, and if the jury reacts in an emotional way, it might succeed. If they go down the legal route, then it won't be as powerful as it could be. So.
And don't forget as well that this is the, today is we're coming to the very end of the plaintiff's presentation, and then they stop with their witnesses and people that they've called, and then we go on to hear the defense. So, it wasn't there was no killer blows. I didn't feel, And then we had Victoria Weatherford, by the way, the lawyer for Rand Simberg, his own lawyer, cross-examine him. And I thought that was very nice. I mean, she started off by establishing how unusual it was for him to be in a courtroom in the first place. Like, have you ever been in a courtroom like this before? And I think he said something like, I think I contested a traffic ticket once. He was definitely finding it.
Yes.
It's a very intimidating environment, by the way.
It is. And it's funny, the new courtroom is more intimidating because it's big, it's cavernous. The other one looked like a kind of a pretend courtroom, like a little side office. This is how courtrooms should look in media.
Very impressive.
Very impressive, and people are distance away, and there's a whole jury bench and all that. So she asked Rand Simberg about, he had all these hyperlinks in this blog post, and she asked, why so many links? And, this looked good for Rand Simberg. He said, because he wanted people to read what he had read.
And to make up their own minds.
Yes.
Very much to make up their own minds and to sort of, join him. Because I think he does explain the blog world, the blogosphere, and that it's much more of a conversational thing, unlike writing an article.
Yes.
That comes up as well.
Yes, and then I liked she asked him about the idea of torturing data, and the plaintiff was trying to say, Michael Mann was trying to say, you're comparing me to Jerry Sandusky, torturing and molesting children. But Simberg said, well, it's also, it's a famous quote by a real Nobel Prize winner, the renowned British economist Ronald Coase, C-O-A-S-E, and he famously said, if you torture the data enough, it will confess. And that's really what Mann did, allegedly.
So actually it makes it sound like the molesting of the data and the torturing of the data, in fact, is some kind of a trope in the scientific world, because it's somehow an echo of what this Ronald Coase had said before. You know, if you torture the data enough, it will confess. It's very funny, you know.
We like
and that was, as you said, Phil, that was said by an actual Nobel Prize winner. Boom, boom. Do you get that reference? For those of you who are being very faithful and listening.
Then Weatherford reminded Simberg that Michael Mann's lawyer Williams had said, oh, Simberg, you yourself have called yourself a denier. And Weatherford asked him about that. And his response basically was, you know, I'm not denying the planet is warming and humans contribute. I'm just skeptical. But let's hear Rand Simberg explain why he shouldn't be called a denier and what he's actually skeptical about. So it's kind of his idea of the world.
And then let's look further down to where Mr. Williams excerpted from the blog post where you say, I reached a tipping point, now consider me a quote denier. Now, Mr. Williams didn't ask you what you meant by that. He asked you to say it. Yes, you said it. What did you mean by this?
First, I must point out that Mr. Williams is being disingenuous. First, he said, you admit you're a climate denier, correct? And I said, incorrect. Because A, the word climate doesn't appear in that sentence, and B, he said the quote, but he didn't point out what the meaning of the quote is. It's like if you really read it out loud, you would say, now consider me a denier. It's sort of like if you put so-called in front of it. I don't really mean it.
What do you mean?
Well, when I said I'm a denier, well, I'm not a denier that global warming, that the planet has been warming. I'm not a denier that humans had contributed to that. But if you go to Exhibit 49, or yes, 49.
Why don't you just tell us first?
I have a long list of things that I do deny.
Can you tell us first?
Tell you what I do deny?
When you say, now consider me a denier, what do you mean by that?
Denier in quotes.
I know.
It means that I believe what... I was kind of upset when I wrote that, and what it really means is that I'm kind of skeptical about the validity of the climate science up to this point. I'm seeing what I think is actual deception resulting from the ClimateGate emails. That's really what I'm saying.
When you say that you have been skeptical of climate science, are you referring to climate change, or are you referring to the issues that are in this case, which is the research around the historical temperatures?
I was referring to really the hockey stick and all the hype it got, in particular at the IPCC.
So the next moment that I felt was a very, very strong moment. Mm-hmm. And again, remember, we're still in the plaintiff's territory right now, and it's great for the defence to be scoring goals in that particular field. But we had Miss Weatherford had a very powerful moment today. She played a 3-minute video in the court of Professor Richard Mueller, who is a professor of physics at UC Berkeley, explaining exactly what is the problem with Mike's trick to hide the decline.
That's the famous email from the ClimateGate emails, and she managed to get it in because Rand Simberg had linked to it in one of his articles. It's very, very effective, I think, because it's a credible criticism of the hockey stick and the ClimateGate emails from an unimpeachable professor at a very prestigious university. So it takes it out of this idea that criticism of the hockey stick and criticism of ClimateGate is just two cranks, Mark Steyn and Rand Simberg. No, it's a professor of physics at Berkeley. And
I think what your point is really good there, Phelim, because this is very important for the jury, because the jury are hearing Mark Steyn and Rand Simberg being kind of described as you say, kind of like as cranks or whatever, and being critical of these austere climate scientists, these extraordinary climate scientists. So let's hear then, So basically then, and I was just amazed that she got this in, but obviously she got this video in because it had been linked to one of Rand Simberg's articles where he's talking about the 𝙎𝙤𝙬𝙊.
So let's play that video now. It's 3 or 4 minutes. And
So this is the actual, you're going to get to listen now to the actual video that was played in court. This is not a reenactment. This is not an actor. And by the way, for those of you who are interested, what we'll do is we'll put the link to the full video of this, because I think there's a 52-minute video, whatever. But we can put the link up in the show notes if people want to check it up later on.
So this is Professor Richard Mueller, Professor of Physics at UC Berkeley, explaining what is wrong with 𝙤𝙤𝙬𝙀 and the climate-gate emails.
Now, what about the climate gate? The scientists have now been exonerated, acquitted, not guilty. They did get a wrist slap. They deceived the public, and they deceived other scientists. But they did nothing that was immoral, illegal, or anything like that. What did they do that deceived the public? This is in the report. This is in the review, not the charts. But these are the data as they published it on the cover of the World Meteorological Organization magazine. These are the data that many of my fellow scientists at Berkeley use. They say, well, the public may not understand graphs, but I do. And look at this. Here's the temperature for the last 1,000 years going over the place. It's not actually temperature. We actually measure tree rings and and corals and things, but it's a proxy for temperature. It goes all over the place. Then look what happened recently. Zoom. That's clear and incontrovertible. The public may not understand this, so I have to now lend my prestige to this. I'm a professor of physics, and I will now go and tell people that global warming is clear and incontrovertible because I have seen the actual data, and it is. And unfortunately, a lot of my colleagues have behaved in this way. In their paper, if you dig into it, they said they did some things with the data from 1961 onward. They removed it and replaced it with temperature data. So some of the people who read these papers asked to see the data. They refused to send it to them, the original raw data. They used the Freedom of Information Act. The Freedom of Information Act officer, on the advice of the scientist, would not release the data. Then the data came out. They weren't hacked like a lot of people say. Most people who know this business believe they were leaked by one of the members of the team who was really upset with them. So now I can show you what the data that they refused to release, the original data, before they did anything. What they did was, and there's a quote. A quote came out in the emails, these leaked emails, that said, let's use Mike's trick to hide the decline. That's the words. Let's use Mike's trick to hide the decline. Mike, who's Michael Mann, said, hey, trick just means mathematical trick. That's all. Now, and my response is, I'm not worried about the word trick. I'm worried about the decline. What do you mean hide the decline? Let me show you this. Now we have the data. Now it's been released. And this is what it is. That's the raw data as any Berkeley scientist would have published it. He would have said, okay, we've had the medieval ice age, and now we have global warming. And there's some disagreement, but hey, there's disagreement all over the place. And that just shows the technique isn't completely reliable. What they did is they took the data from 1961 onward, from this peak, and erased it. What was their justification for erasing it? The fact that it went down. And we know the temperature's going up. Therefore, it was unreliable. Is this unreliable? No. How do we know? Well, we don't know. But, this is probably some human effect. The justification would not have survived peer review in any journal that I'm willing to publish in. But they had it well hidden, and they erased that, and they replaced it with temperature going up. And let me show you how cleverly this was done. You get back to this plot. There it is. They added the same temperature data to 3 different plots, giving you the illusion that there are 3 different sets going up. And they smoothed it. This temperature changes smoothly. If they hadn't smoothed it, you might have noticed, oh, wait a minute, what's the change going on right there? Why is it abruptly different? But you don't notice that because it's smooth. But smoothing is legitimate in their minds because the temperature change is not discontinuous. So that's what they did. And what is the result in my mind? Quite frankly, as a scientist, I now have a list of people whose papers I won't read anymore. You're not allowed to do this in science. This is not up to our standards. I get infuriated with colleagues of mine who say, well, it's a human field. You make mistakes. And then I show them this. And they say, no, that's not acceptable.
I mean, there was so much great stuff in that video. What I felt was the most devastating part of it was the students' laughter. I mean, it's hard to recover from being laughed at. I mean, especially by students at a university. And
students at UC Berkeley who, found the situation that he described, the height of the decline, and the decline in particularly, where the graph, and obviously you're listening to this podcast, but we were watching on screens with the graph being shown to the jury, where you suddenly saw what Mike's trick to hide the decline exactly did. So it turned a line in the graph from going up to infinity, as you saw in so many places, and you've seen the hockey stick graph. It basically broke the hockey stick. So the hockey stick was broken today, is how I feel, to the jury. And it was broken, as Phelim described, by an unimpeachable source, by a UC Berkeley professor of physics.
Independent third party.
So I definitely thought it was a very big score. So we finished up then with, that was the end of Rand Simberg, basically. It kind of ended then. And we then got the plaintiffs to bring their final witness, and that is Dr. John Abraham. And there was argument earlier as well about whether or not Dr. John Abraham would be even admitted as an expert in anything. But they eventually, after lots of argument, and we do have a lot of argument going back and forth, by the way, during the day, and lots of white noise and lots of objections. It's a very dramatic courtroom, by the way. But then we got to John Abraham very late in the day. So he is from the University of St. Thomas in Minnesota, an engineering professor, very highly qualified. He has 20 patents. He knows an awful lot about water, 150 presentations at conferences, 300 peer-reviewed journals, invented a process for cleaning dirty water so that people in the developing world could drink water, safely. So, he very credentialed in terms of science and all of that.
And he's known man for 15 years, says he's an excellent scientist. They've published together. He was called to show damages. And this is the first time, and I think the only time, that we have an independent sworn verification, alleged verification, that Michael Mann suffered damages as a result of the connection with Jerry Sandusky. So let's hear Abraham, Professor John Abraham from the University of St. Thomas in Minnesota. Let's hear him describe how Michael Mann was damaged by the allegedly defamatory articles.
At the time of the publication of the Simberg and Steyn articles, were you working on any scientific studies at that time?
Yes, I was.
What was that?
I was working on actually a major study that dealt with oceans and ocean warming and how the oceans are responding to climate change. There were many authors on that study.
Why were there so many authors?
Well, if you look at this paper, this was what's called a comprehensive review, and we needed a lot of data, and there were many authors involved in this paper. I think 28 authors. Because each of these authors brought their own data, their own measurement information, and their own knowledge about the oceans to our team, this was a carefully crafted team that was able to provide this comprehensive review.
Okay, and this was published in Reviews of Geophysics. Could you speak to that journal's reputation?
It's one of the best, one of the hardest to get into, one of the most prestigious journals.
Were you primarily responsible for recruiting the team for this study?
I would say I was fully responsible. This paper was my initial concept, and I was responsible for assembling the team.
How did you go about it?
I first inquired what kind of data do we need and where is that located? I brought in scientists from around the world, from Asia, Europe, and the Americas. I needed their data, and I needed their interpretations of their data. That was one of the elements that I considered as I assembled the team. I also needed people with special expertise to help us understand the data and how it interacted with the rest of the Earth's climate.
Now, what data were you looking for with this study?
The most important data that we were looking for was past temperature measurements. We went back, I think we may have even had data back to 1750 in this paper, but definitely many decades in the past. And so we needed data from different laboratory archives.
Did you have knowledge at that time when putting together the team of Dr. Mann's reputation?
Yes, I did.
And what was your knowledge of his reputation?
My knowledge of his reputation, especially in paleoclimate, is that it was excellent, and atmospheric oceanic interactions. He has an excellent reputation for publishing top quality research, and he's often been at the forefront of different research endeavors.
In 2012, had you read Dr. Mann's publications?
Yes, of course.
Okay. And did you consider adding Dr. Mann to your research team?
I did.
Did you add him to the team?
I did not.
Why did you not include him in the team?
It was too risky.
Why did you conclude it was too risky?
Because I was concerned that other co-authors would not be willing to have their name on a paper that Dr. Mann was also a co-author of.
You just testified that he had an excellent reputation. Was there something that caused you to have concern about other co-authors being concerned about having their name associated with his?
Well, yes. At the time, Dr. Mann's reputation was excellent in his field of study, which was, a lot of it was confined to paleoclimate. This is the ocean heat content. This is a different area. These people didn't know him. Many of these...
Objection. Move to strike.
Sustained. Please disregard the question and answer.
So that bit at the end there, that was a white noise moment when they put on the white noise and have an argument among themselves. From what we can see in the courtroom, I think that Abraham was really giving hearsay. He was saying what other people thought and felt about Dr. Mann, and he's not an expert on what other people think or feel, and he can't say.
And the plaintiffs hadn't brought any of those other people in,
right.
And they could have done that, and they had 12 years in which to do that. So we don't know exactly what Judge Irvine was thinking about there, but this could be significant, and it's not over because that was the end of that piece for today.
But I would just like to say, this is very clever, and they do this a lot. They ask a question, get half an answer in, and the judge goes, jury, ignore that. And of course, how can you do that? And both sides have done it, to be fair. You know, both sides have done it, but it's certainly gamesmanship. So, as I say, this was the first example of Michael Mann proving or having someone to say he was damaged, and it could be significant. But don't forget, there's cross-examination of this witness tomorrow. Mr. Abraham's going to be cross-examined tomorrow from Steyn and Rand Simberg's lawyer. So we'll have to see how his evidence stands up to under the part oil and vinegar of Miss Weatherford and Mr. Delaquil and Mark Steyn. They're quite a combination. So let's see tomorrow, does the damage still stand? So that's the end. That was the end of the trial today. Yeah,
but I think what's important as well, just from a kind of from the functional point of view and the structural point of this court case, to understand that tomorrow will be, our next podcast will be dealing with the plaintiffs will rest, within an hour, I think, of the morning. I'm hoping within an hour of the morning. I think
if the jury turn up.
If the jury turned up. And by the way, just to understand, the plaintiff's case should have finished last Thursday and instead has gone on through this. So this is also going to affect the timetable, and we're wondering, will we ever get out of here? So basically what's going to happen tomorrow then is the defence will start their case, which is going to be very interesting.
So we're at a turning point, actually. At the end, Michael Mann has had to have proven his case by now. Now, the rest of the case is going to be dedicated to Steyn and Simberg trying to demolish Michael Mann's case. I wouldn't call his case the strongest I've ever seen in a court of law, but again, DC jury, East Coast jury, not the most welcoming of place for conservative writers, for climate skeptics. So let's see where it goes. There's no clear indication where this case is going. So thank you for listening.
Keep leaving reviews and rating us. It makes a huge difference. And I promise you, late at night, we're reading everything.
Yes.
We're still in the top 10 of science podcasts worldwide, which is extraordinary. But we want to keep climbing. We're obviously...
Send it to all your friends, please. And don't forget, if you want to help us keep doing what we do, it's very important. Please donate. We're a 501c3. Your donation is tax deductible. So go to unreportedstorysociety.com. That's unreportedstorysociety.com. It helps us do what we do. And believe me, it's never been more important.
Thank you so much.
Thank you. Bye.
Bye.
Climate Change on Trial is a project of the Unreported Story Society. It's presented by Phelim Scoop and Ann McElhaney. Written by Ann McElhaney, Phelim Scoop, and Virginia Abram. The executive assistant was Annalisa Pesic. It's edited by Peter Kelly and produced by Phelim Scoop and Ann McElhaney and Magdalena Segeda. Reenactments were directed by Kif Scholl. Nico Garfolo is the engineer. Mark Steyn was played by Tom Bromhead. John B. Williams was played by Keith Allen. Judge Alfred Irving was played by Michael Shepard. Rand Simberg was played by Tom Fasella. Mark 𝙤𝙤𝙀𝙀😘 was played by Matt Downs. Victoria Weatherford was played by Erica Ibsen. Peter J. Fontaine was played by Michael Delata, and Dr. John Abraham was played by Peter James Smith.